impact of artificial intelligence in judiciary. We are at the moment on unexplored lands, something like Lewis and Clark, who explored the western parts of the North America. Anyhow, judiciary and judges are at the moment between the high, unrealistic expectations of the public and the realistic approach to those who know what judging is about. And I think that today we will see some sense to the topics. And it's my pleasure, and I'm very honored to introduce our speakers today. It is Edmund Beerwinkle. It is Marilyn Huff, President of the First Study Commission. It is Margaret McCowan, President of the Fourth Study Commission. Leonie Reynolds, which is not here with us, but I hope she will come, the President of Consultative Council of European Judges. Giacomo Berto, Secretary General. And at the end, Maria Badeva, who will wrap up the conclusions. Thank you for your attention. And now I will give the floor to Edmund Beerwinkle, who will start with his presentation. Thank you.
Good morning, ladies and gentlemen. Thank you for the opportunity to speak to you today. As been said, this is a new topic for all of us, and we're all learning. And my job here today is the easiest one. I think the difficult ones are coming with the rest of the speaker. I was just tasked to give a bit of an introduction around AI, see what's out there, highlights of the risk and opportunities, and also just to bring everybody some key definitions in terms, we come from different jurisdictions, different perspectives, and different levels of understanding of AI. And this is just to kind of set a bit of a foundation that we all can operate from, so just bring people up to speed a little bit with what's out there and things like that. So I hope it's informative, and I apologize for those who already know these things. And there are definitely some of you in the room, and you might find it a bit boring, but hopefully the person next to you find it a learning experience. And so I apologize for that if it's some stuff that you already know. So AI has been with us, artificial intelligence has been for us. Some people think that it's only started now in October, November 2022 when ChatGPT was let loose on the world. But it's actually long before then, as most of you would know. I think around about the 15s that artificial intelligence were with us already. And also in the courtrooms, digitalization has started already with the introduction of electronic evidence in the courtroom, the shift from physical document to electronic formats, which at first, like anything new, experienced some skepticism, but eventually transformed the judicial process, making evidence more accessible and easier to analyze. The rise of digital shared evidence, the use of e-discovery, and the acceptance of court documents electronically, all of which have enhanced legal proceedings by enabling more efficient gathering, sharing, and review of large volumes of electronic data. So we've been on this journey for a while. What we are witnessing now and experiencing now is AI as the next transformative technology that could reshape judicial workflows. So just a simple, what is AI, and a simple kind of understanding of it is just really, it's giving machines human-like capabilities, just emphasizing how it's already, and these are already in our lives. If you look at the Google Maps, Spotify playlist, Meta, Alexa, Netflix, the movies that they dish up to you, these are all AI-driven, and we're already experiencing it. So again, not new. Sometimes we don't realize it. So it becomes so part of what we're doing and what we're experiencing that we don't realize that we're actually experiencing AI. So it's already part of our daily existence. So just some key terms. So there's the AI systems definition from the OECD, and it's there on the screen. The system is a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, content recommendations, or decisions that can influence physical or your virtual environment. It's useful, and I know lawyers like definitions, defining things, so that's a useful starting point for everybody on the same page. When we talk about an AI system, that's probably the definition that one would reference. Then some other, I think I mentioned AI. So AI is the overarching discipline and used to describe both basics and complex systems. AI is a machine's ability, as I said, to perform the cognitive functions we associate with humans, such as perceiving, reasoning, learning, interacting with an environment, problem solving, and even exercising creativity. And then there's machine learning, ML. It's a form of artificial intelligence based on algorithms that are trained on data. These algorithms can detect patterns and learn how to make predictions and recommendations by processing data and experiences. The algorithms also adapt and respond to new data and experiences, and obviously improve their efficiency that way. And then there's deep learning. Deep learning is merely a subset of machine learning that uses neural networks with many layers to analyze various factors of data. It is particularly useful for tasks like image and speech recognition. So, for example, call centers are using these. The AI or the chatbot that is taking a call can detect the tone of the voice of the customer calling in. And if it's an angry voice or a frustrated voice, they will direct that call to a human. That's already being done. It's not new. So then there's, of course, generative AI, which is the one that in some people's mind, 2022, October, November, that's when AI started, but it's really generative AI that was introduced to the world through ChatGPT. And the generative AI creates new content such as text, images, or music. It is an AI model that generates content in response to a prompt. And prompting is merely just asking it a question. Prompting in itself by now has become a science, asking the right questions. And of course, with an audience like you, asking the right questions and questioning comes naturally. So I don't think you need to go do a course in prompting. It will just come to you. It is clear that generative AI tools like ChatGPT and DALL-E, which is a tool for making AI-generated art, have the potential to change how a range of jobs are performed. The full scope of that impact, though, is still unknown, as are the risks. I did speak about neural networks, I mentioned that. So it's merely a series of algorithms that attempt to recognize underlying relationships in sets of data. And it's really merely being inspired by the way the human brain works. Large language models, LLMs. No, it's not a master's in law, as you might think. Large language models is a type of AI that uses neural networks to understand and generate human-like text, such as the technology behind ChatGPT. LLMs are AI models which learn to predict the next best word or part of a word in a sentence that's having been trained on a data set of enormous quantity of text. So ChatGPT, OpenAI language, Chat Bing used the OpenAI's large language model. OpenAI is the company that gave us ChatGPT. Then another term that you will come across is that one, Retrieval Augmented Generation, RAG. So RAG is, so you would have heard about the hallucinations that some of these machines, these tools generate. I don't have to go into the court cases, you're all familiar with that, you would have read about it. But so what the legal publishers or legal research companies have done is to develop a model that, the RAG model, which is really, it combines the retrieval of real-time information with AI generation. It's intended to enhance the quality of accuracy for AI-generated responses. So some global research providers have developed methods like RAG to eliminate or avoid hallucination. So what RAG does, it allows the system to first retrieve the relevant in simple terms, retrieve the relevant source material and then use that material to generate the correct response. Whereas with open systems like ChatGPT, it searches across a vast things and then generate an answer, which increase, as you can see, the opportunity for hallucinations. Although the RAG models are not perfect yet, they are still being worked. I think there was a Stanford report in May earlier of this year, which evaluated 2 systems from 2 legal research companies. And they found they were still between 15 and 33%, 17 and 33% of hallucinations occurring with the RAG models. I'm sure that between then and now, which was May, up to now, there would have been further developments to make that a little bit, to bring that ratio down or that percentage down. I haven't seen the latest report from Stanford on that, but yeah, I think RAG just gives that extra kind of confidence in the responses that you get. So this is just an example of some of the generative AI tools that are out here. Again, I'm sure that these are tools that you are all familiar with. ChatGPT needs no introduction. Claude, it's an AI assistant created by Anthropic, which is the company, designed for various tasks, including analysis, writing, coding, and problem solving, and aims to be helpful, honest, and ethical. That's what Claude says. And it says, on its site, it says, if you can dream it, Claude can help you do it. So, yeah, I use Claude personally. It's my personal preference, but everybody has their own preference what they be using. Then there's Perplexity. It's an AI search engine that provides direct answers to questions by analyzing and summarizing information from multiple web sources and provides the links to these sources. We also have Microsoft Copilot, which you are familiar with as well. We use Microsoft Copilot in our business. It's nice when you have meetings, it transcribes it, summarizes it for you, and you can also, I use it when I need to search for something across our internal documents and databases to find something, and it does that. The other day I had to answer some questions around strategy, things like that, and I put the question into Copilot, and it searched all the documents I've had on strategy over the years and came up and told me where we're at with that at the moment, which was quite useful. So I think these tools does have benefits, and again, it just comes down to how you use it and, of course, the responsibility and ethical use of it. Then the Synthesia is an AI video generation platform that creates video content using synthetic avatars and voices, primarily for business and educational purposes. And of course, Google Notebook LM, which you can upload PDFs, docs, etc., and it summarizes it for you and make connections, identify trends, things like that. So each of these tools have different strengths and use cases. ChatGPT are more general purpose, conversational AI, while Perplexity focus on search and information retrieval. Microsoft Copilot integrates AI assistants into Microsoft's ecosystems. Synthesia specializes in video creation, and Google's notebooks, of course, are more focused on providing tools and infrastructure for AI development and research rather than being an end-user product themselves, although they do power many end-user products. Then there's also example of some AI legal tools. Harvey, which some of you may be familiar with. Harvey is an AI-powered legal research analysis tool. It's designed to assist lawyers with various tasks, such as legal research, case law analysis, contract review and drafting, and due diligence. It can also answer complex legal questions. Then there's Leia. Leia is an AI-powered legal assistant developed by Wolters Kluwer, and it's designed to provide quick answers to legal questions, offer legal research assistance, etc. And then there's Lee. It's a legal electronic artificial helper. It's an AI tool developed by Xdraft, and it focuses on contract automation and management, legal document drafting, review, streamlining legal flows, etc. And of course, then Relativity, primarily an e-discovery platform that uses AI to assist with document review and analysis, data processing and organization, case assessment and strategy, investigations and compliance. And of course, Thomson Reuters Co-Counsel, which most of you would be familiar with as well, is an AI-powered legal assistant developed by Thomson and it features legal research analysis, contract analysis, due diligence, litigation analytics, etc. And Spellbook is an AI contract drafting and negotiation tool, automated contract creation, etc. So these tools are aimed to increase efficiency and accuracy in various legal tasks, from research and document review to contract drafting and case analysis. They leverage AI and natural language processing to assist legal professionals in their day-to-day work, potentially saving time and hopefully reducing errors as well. It's worth noting that these tools can be very helpful. They are designed to assist legal professionals rather than replace them. The interpretation and application of the law still require human expertise and judgment. Then I think a very important topic to take note of, and I think we'll hear more about this, is the challenges in risk relation to AI in relation to judicial activities. So I think I touched on hallucination, and the hallucinations can occur in a few ways. An AI tool might just be incorrect. It describes the law incorrectly or make a factual error. A second response, maybe it might be misgrounded. The AI tool describes the law correctly but cites a source which does not substantiate the particular answer that is given. Another response is that of sycophancy, and that's a tendency of an AI to agree with the user's incorrect assumptions. So when you prompt it in a particular way, it wants to please you, so it's going to tell you what you want to hear in some cases. So that also poses a unique risk in legal settings. So many lawyers globally have already submitted hallucinated cases, court cases during proceedings. I think you're all familiar with that. No need for me to explain more on that. There is the case of an expert witness not too long ago who used Copilot to do some calculations. I think if you're from the US jurisdictions, you might be familiar with the case. And the calculations that was done by the expert using Copilot turned out to be incorrect. And he disclosed that he was using Copilot. So when the judge tried it a few times, the judge got a different answer every time that he tried it. So that just shows you, again, be very careful of how you use these tools. They are not as perfect as some would like you to believe. Bias and discrimination. I think there's a lot have been said about this as well, and I think people are well aware that that can happen. So there was the Mobley and versus Workday case, again in the States, about recruitment, where an AI hiring platform allegedly excluded certain groups of employees from job opportunities, which called into question the fairness and neutrality of AI hiring platforms. So Mobley was a black American male over the age of 40 with a disability, and he alleged that the AI applicant screening platform, Workday, discriminated against him and similar applicants. It was alleged that Workday's algorithm systematically disadvantaged black applicants, older applicants, and applicants with disabilities, leading to their exclusion from job opportunities. So the court allowed Mobley's claim to move forward, recognizing that even though Workday did not intentionally discriminate, its AI had unintended but disproportionately negatively impact on black applicants, older individuals, and people with disabilities. So this case highlights the potential for AI systems to replicate biases from data on which they are trained. AI relies on data to predict outcomes and make recommendations. If the data probability reflects societal biases, whether on race, gender, age, or disability, then AI is likely to perpetuate these biases. Then there's deepfake evidence. Again, no need to say much about that. I think we're familiar with some of the reports that has come out around deepfake, how these videos created by around a personality, and they are saying things that they wouldn't normally say if it was them truthfully speaking themselves. There's also intellectual infringement, property infringement. Again, number of cases pending around that, which is it started with the big AI companies scraping information without getting permissions for it and things like that. Just this morning I was reading an article where I think one of the big publishers in the US that's now going to put into, I think it's Pearson Random House, if I'm not mistaken, going to put in their books that it cannot, you normally have the copyright infringements and piracy and all that. So now they're going to add to it that it can't be scraped for AI purposes. So that's the kind of strategies that publishing houses are coming up with to try and protect their intellectual property. Then, of course, data protection and regulatory uncertainty. This is very important as well. It's difficult to ensure which privacy laws, particularly across jurisdictions, that it's the same or that it allows for the protection of your information and things like that. So it's a changing regulatory landscape. I think the EU Act kind of tries to move towards the regulation of that particular space. I was reading something on the IBA has last in September brought out their report. I don't know if some of you have seen this on the future of AI. The future of AI is now. Impact of AI on the legal. The future is now. Impact of AI on the legal profession. It's a very interesting report. If you have time, go download it from the website. It's freely available, where they talk about the regulation of privacy information and how to regulate in the different jurisdictions. And they were wondering how an organization like them with members across the globe, like this organization, what can they do? How do they do it? Because the jurisdictions have their own rules and regulations and regulatory requirements. And I think what they're thinking of is to come up with a body of principles. As a global body, they want to come up with principles that will hopefully feed into the regulatory framework that's being developed in the different jurisdictions. But I recommend that you have a look at that particular report. It is about private legal practitioners, it's about law firms, but I think you'll find synergies and alignment with some of the challenges that is being faced by your organization as well. Okay, I'm going to move on a little bit quickly. I think I'm running out of time. Yeah, okay, I am out of time. So I think what are the potential opportunities? Yeah, you could have you could use AI, the tools like we've mentioned now for brainstorming. You can do it for research and learning, just staying abreast. For example, if you are sitting in a matter that you are not familiar with, they talk about quantum computing. Then maybe you just want a quick understanding of what quantum computing is about. So you could put into your, whether you're using Claude, and just say, give me a quick understanding of quantum computing, but a response about as if I'm a 5-year-old or a 12-year-old or a 10-year-old. Make it very simple. And then it gives you a gist of what that is about. So that's how you could use it. It's also decision-making assistance. It can increase productivity, etc. I think there's I think I'm going to just skip through. Oh, sorry, that's too far. Okay. The articles that I found, I know there's a US judge, I think is Judge Schlegel, who writes prolifically on AI in the courts and in the courtrooms. And some interesting stuff there. You don't have to agree with everything he says, but it's always good to see that and maybe challenge your own thinking around it. So if you do have time, just look him up. He's got a blog, and he's written a number of articles on this topic in AI in the courts, which could be very useful to look at. Then just to end off, I think, so when one imagines a future courtroom where AI seamlessly supports the judicial process. A judge uses an AI assistant to quickly and accurately analyze case precedents, summarize key arguments. Real-time AI interpreters are available in any language, ensuring fair access for all participants. In-court AI systems help explain complex jargon or technical terms to ensure clarity for everyone. An AI agent handles administrative tasks, receiving and reading court documents, settling court dates, and organizing evidence, freeing judges to focus on deliberation and decision-making, potentially. AI on the bench can act as a decision-making aid, offering insights while respecting judicial independence. This vision is not far from reality. It is a glimpse into how AI could alleviate the could elevate efficiency, fairness, and accessibility and justice in the court. The key question, however, is, as custodians of justice, how can we ensure that this powerful new tool is wielded responsibly and ethically? Ladies and gentlemen, thank you. That is the end of my presentation there. I just want to point you to that. We will be, JOASA will be offering a free seat on the seminar, Open AI Legal Accelerator. It's by Naruska Barwin. She's the founder of that institute. It focuses on AI and law, innovation, technology tomorrow. That's what LIT stands for. It's the LIT Institute. She's offering a seat on a 3-day webinar. It's online. It's not a full 3 days. It's a few hours a day, and it's in the middle of the day, so you can work around that. If you put your business card in a bowl somewhere, I think they're by the table, we will do a bit of a lucky draw, and one lucky contestant can win a free seat into her next session, which starts around about the middle of November. I've been on the course. It's a good, solid foundation if you want to get into AI. Gives you an overall view, especially AI and the law. And yeah, so very useful. So she's also collaborated with me in the presentation that I've just done. So it's not all me. I got to give credit to her as well. She's done a great job for us. And I collaborate with her quite often on these topics. Thank you, ladies and gentlemen. Thank you for your time.
Thank you, Professor Birwinkle. Now I will introduce Marilyn Huff. She will speak about artificial intelligence on the judiciary as a whole, so how it impacts the judiciary. Just for a small sentence, I read an article in New York Times recently that one lawyer was fined by the court because he presented a case law which was invented by the artificial intelligence, so there was no such judgment. But artificial intelligence wanted to be helpful, so it created the judgment which doesn't exist. So he was fined for that, for misleading the court. So not one of the answers is how that should not happen will be answered by the Marilyn Huff, please.
Thank you to the professor for setting the stage for my discussion, and my topic is the effect of AI on the judiciary as a whole. In current practice, there is a wide variety of the use of AI. Some countries report the more traditional intellectual technology applications. Many countries report that they are piloting new and potentially transformative programs to see how it's going to work. And then there are countries that are far advanced in their AI applications. The country-specific answers are on the First Study Commission's website under the public session, so you could see what all of the countries are doing. But let me just highlight a few of the countries that have more advanced applications. In Austria, judges regularly use AI-powered technology for legal research and AI-powered dictation software. I think AI-powered dictation software is quite common across the board because it really works quite well. In addition, the courts utilize a chat box for citizen services inquiries on the court's website called Justice Online. The chat box is able to recognize the questions presented and then provide answers, freeing up court staff. In France, the judiciary uses AI for anonymizing court decisions. Many countries do that before public dissemination, which permits more public dissemination and hopefully enhances the confidence in the judiciary by being able to provide the public with anonymized court decisions. The Ministry of Justice is developing an AI-powered bodily injury compensation framework to improve the predictability of decisions in that area of the law. In Kazakhstan, who wasn't able to be here, they already have software that drafts judgments. There's not a judge. They just draft judgments on low-level cases where they say the evidence is not contradicted, and there's no evaluation of the evidence. In Sweden, judges report that on an individual basis, they've used ChatGPT to draft decisions. And the judiciary has used AI for data analysis, translation, anonymization of documents, automatic transcription, and interpretation. In Taiwan, not surprisingly, given its nature on chip development, they're quite advanced. The courts are considering using AI to draft judgments for high-volume standard cases, such as driving while under the influence or aiding fraud. But they emphasize that the AI system only acts as an aid in drafting the judgment and does not replace the judge's decision-making. In addition, in criminal cases, when it gets to sentencing, they have predictive data analytics that goes through all of the factors, and the AI tool then recommends a non-binding sentence for the judge to consider. In the United States, we have an AI tool called Quick Check Judicial, and that allows court users to upload multiple filings to receive a comprehensive report detailing the authority cited by both parties and significantly omitted authorities. So I used Quick Check Judicial as a check. I had a case, it was a data breach case, my judgment was already done, I felt 100% confident in the judgment. So I uploaded the party's brief into Quick Check Judicial to see if it matched, if it gave the correct cases and any omitted cases. And to its credit, it did. It worked quite well. Let me now turn to the regulatory and guideline framework. As we expand on the use of AI, many countries and international bodies are developing guidelines and regulations for use by the judiciary. These frameworks emphasize ethical considerations, transparency, and the protection of fundamental rights. The evolution of these regulations will be crucial in shaping the future of AI in judicial systems. Not surprisingly, in the United States, it's kind of the wild, wild west, and everybody's kind of doing their own thing. We have a lot of commercial companies that are developing these products. But not surprisingly, the EU and England and Wales have kind of taken the lead in coming up with some quite good guidelines, and the EU is taking it a step forward and has passed the EU Act, the AI Act, that will go into effect in 2026. The European Commission for the Efficiency of Justice issued the European Ethical Charter on the use of AI intelligence in judicial systems. It cited principles, high-level principles, that any court should consider in deciding whether or not to use an AI system. They include the rule of law, judicial independence and impartiality, judicial autonomy, judicial oversight, accessibility and quality, continuous improvement, piloting, non-discriminatory design and operation, transparency, accountability, integrity, security and data protection, openness and privacy, and finally, training and funding. These are important principles that we will have to consider in any use of AI. Additionally, England and Wales released judicial guidance called Artificial Intelligence, Guidance for Judicial Office Holders. The guidance sets forth 7 points for the responsible use of AI by courts and tribunals. One of them is very practical. Judges should understand what program you are using and make sure that you do not compromise privacy or other concerns. These are on the website of the IAJ under the First Study Commission. They're very thoughtful, and I commend you to reviewing these. Now let's turn to the effects of AI on the administration of justice. Here it's most promising. Most countries anticipate significant improvements in efficiency, faster case processing, improved consistency in decision-making, and enhanced access to legal information. These improvements in speed and efficiency could lead to the quicker resolution of cases, assisting the courts in managing their caseloads and providing litigants, importantly, with speedier access to justice. This will hopefully strengthen the faith and confidence in the judiciary. On the flip side, there are also concerns about the effects of AI on judicial independence. Let me address those. The proper and effective use of AI by the judiciary can assist judges in making more informed and well-reasoned decisions, which can bolster judicial independence. But an over-reliance on AI by the judiciary could harm judicial independence by discouraging judges from relying on their own experience, moral judgment, and values in decision-making, and eroding or disempowering the judge's ability to exercise discretion. Too much standardization through the use of AI could reduce a judge's ability to tailor decisions to the particular circumstances of each case. A judge could turn into a mere supervisor of the AI tool as opposed to being the ultimate decision maker in the case. This could lead to justice governed by the private creators of the AI software as opposed to judges. Therefore, any implementation by AI by the judiciary should ensure that judges retain the ultimate power as the decision maker. The professor talked about deepfakes. Let me briefly turn to the effects on AI on the evaluation of evidence. AI might also play a role in the judge's evaluation of evidence presented by litigants. We already have these issues on, is a photo a true and accurate depiction of what was done at the time? But now AI takes it to another level because AI can create evidence, and how do we know what is a deep fake and what is reality? So in light of AI's ability to produce falsified evidence, courts will need to be more cautious in evaluating evidence and ensuring that it's authentic. We've talked about the positive and negative impacts with the use of AI. On the positive side, AI is widely seen as a tool to enhance efficiency, consistency, and access to information. AI research tools can enhance adherence to existing precedents, resulting in a more well-reasoned and consistent decision-making. However, these benefits must be balanced against several concerns. A primary issue, as we've discussed, is the over-reliance on AI, potentially undermining human judgment and the nuanced understanding that judges bring to cases. Over-reliance on AI could also make judges' mental processes more passive, which could lead to errors because AI tools have the capacity to hallucinate, i.e., provide false or erroneous responses. Let me give you an example. In preparing our first study commission report, we had 38 reports. I did my traditional reading of the reports, taking notes, organizing them, making an outline, and then I had a good idea. This is about AI. Let's see what AI would do. So I used the Claude program. This is a spin-off from Google that the professor talked about. And I uploaded the 38 responses into Claude. Now recognize I'd spent more than a week trying to do this myself. And I had only begun. In 15 seconds, Claude said, I'm pondering. In 15 seconds, I had asked it to do an alphabetized summary of what the country responses were. 15 seconds, it did it. Here it started, Australia, Argentina. It went down through the list, and it was a very good response, very much faster than I could have done, with one big problem. It hallucinated. It completely made up a report from India. There was no India report. It completely made up a report from China. There was not a China report. So you can actually communicate it. Claude, did you make a mistake? And I think on China, it confused Taiwan with China, which goes into the issue of bias in these. And to its credit, because I'm told that Claude does not always admit that it makes an error, it said, yes, I made an error, I will not do it again. So this does call into question the reliability, and even on the summary, it then requires human verification of the data. So on bias in AI systems, this is an example of potential bias in the AI systems. Who is doing the algorithm? What are the factors that go into the algorithm? Mexico reported that it uses some AI tool in parole cases, and there are significant biases, particularly against minorities, in the tool that it uses. So we will have to be diligent in monitoring bias in AI systems. The professor talked about privacy. There's also security and cybersecurity concerns. Privacy and security concerns include the fact that if you upload some private information into a program that's open, like ChatGPT, you are violating potential privacy rights of the litigants. Also, intellectual property concerns have to be addressed as well. So AI tools generally need to collect large amounts of data from the parties involved in the process, which may lead to revealing undue or inappropriate personal or private information. Also, judges need to know, is this a program that keeps it, or does it not use it? There's a difference between an open program and a closed program. Also, at least in the US, we've received guidance reminding us that if we just use any tool, it could have malware that would have cybersecurity problems that could impact our entire system. So we'll have to be diligent on that. Accountability and transparency concerns. AI systems also raise these concerns because AI systems are not accountable to the public in the same way as judges. The public can criticize my decision, but the public may not know what tool the courts are using in making these decisions. In conclusion, AI should be a tool to assist judges rather than a replacement of their decision-making role. It is important to maintain human judges as the ultimate arbiters, with AI serving in a supportive capacity. Certain aspects of judicial decision-making, particularly those involving complex ethical considerations or the interpretation of nuanced human behavior, should remain firmly in the domain of human judges. In sum, there is unanimous agreement with the principle expressed in the EU AI Act that states the use of AI tools can support the decision-making power of judges or judicial independence, but should not replace it. The final decision-making must remain a human-driven activity. Thank you.
Thank you for this excellent presentation, which raises our hopes that some sense will be about this enthusiasm of using artificial intelligence in judiciary. So, like that? Is better? Okay. So, thank you, Marion, for this excellent presentation and the message that enthusiasm in using the artificial intelligence in judiciary should be curbed a little bit. Now I'm giving the floor to Margaret McCohen, President of the Fourth Study Commission of EIJ. Please.
Good morning. We're now going to transition from specific use of AI in the judiciary to the impact on the labor market and in society. There is a famous Supreme Court Justice, Oliver Wendell Holmes. He said that a page of history is worth a volume of logic. So I'm going to start with a page of history. When we talk about revolution and changes, the sky is always falling. And the concern is we're going to lose jobs and that society will be incredibly disrupted. So I'm going to start with what I think was the very first of these, and that was the printing press and the publication of the Bible. That, of course, displaced scriveners, but it opened up a whole new global news network. As ships left Europe and went to Asia, went to America, and all of a sudden we had knowledge and literacy that was more universal. It was not confined to the church or to a small group. Then, of course, we had the industrial revolutions, and the concern was there'll be no jobs for people. We'll just have machines. That turned out not to be true. Then we moved to what I call the third industrial revolution, and that was really the advent of computers, electronics, the nuclear time, which is sort of the 60s up to the 2000s, and finally where we are now, the internet and artificial intelligence. There's really been a rapid expansion because if you think about it, the internet was not in common usage until 1995. So that is not that long ago when you compare it to something as long as the Industrial Revolution, which lasted several hundred years. I like this quotation from this gentleman from Massachusetts Institute of Technology because he really framed that there are different kinds of technologies, and the technology we have now has really accelerated the march of economic progress. And there he's talking, as Mr. Beerwinkle talked about, the generative AI. So what does this mean for the economy? Well, there's a startling statistic that 40% of the jobs worldwide will be affected by AI in some way. But it's not uniform. Half of the workers will likely enjoy some kind of enhanced productivity, and they'll have a different kind of a job, or they'll have enhancement to their job. The other half, on the other hand, might face lower wages, lower hiring, loss of jobs. So the net effect really depends on the country and, of course, who are your skilled workers. So I thought it was interesting, too, that the biggest impact will be in advanced economies, 60%. Emerging markets, 40% of the workforce will be impacted. And in lower income countries, 26% of the jobs. So I said it's not uniform. It depends on what's happening in your country or your region. You first have to look at the infrastructure. Is it a highly regimented country or market with a highly skilled workers, for example? And what sector are you talking about? When we think about sectors of employment, there's, of course, manufacturing. That's a very large sector, as is agriculture in many countries. Business and professional, that's where we all fall. The IT industry, construction, banking, aerospace, defense, energy. So it doesn't land the same on every industry or every market. And much of this may depend on, for example, what kind of job motility or mobility do you have? Do you have a static labor market where people don't change jobs? Or do you have, as we have in the United States, a very mobile market? Another important aspect, and one that we look at in the Fourth Study Commission, is what's the strength of labor or trade unions? Because as you begin to impact jobs, the labor unions will be coming in. Many countries have very, very strong unions. In the United States, we had a history of very strong union movement. It then faltered. It's now back in terms of on the rise. But it really matters because what kind of protections do you have? And one of the things we talked about in the Fourth Study Commission is that we have a lot of labor laws and protections in place, and they remain there even when you superimpose AI on that. How adaptable is your country to a new legal framework? Do you need a new legal framework for AI? That's, of course, the debate we're all having now. And then finally, what kind of enforcement do we have? Because we have a lot of laws that are on the books worldwide that are never enforced. So you can have a lot of fancy principles, and you can have a lot of laws, and you can have big, lofty ideas, but if you have no enforcement mechanism, what happens? So let me talk now about some of the benefits of AI for society and labor. The first of these, I think, benefits worldwide, and that's advanced scientific progress. Also, there will be advanced access to healthcare, education, financial, and legal services. All of this will be more accessible, I think. There'll be new job opportunities, jobs that have never been created before. Mr. Bearwinkle talked about, look at all those companies that have been created, and now we're all using these various tools. There will be increased productivity and efficiency, and there's the ability, of course, as Judge Huff talked about, for use of AI in decision-making, but don't take out the human. And then, of course, our whole infrastructure of data and information security. Let me talk about the downsides or some of the challenges. First of these, of course, is a loss of trust in information. And once you have one or two egregious examples of hallucination or basically data fakes, then people begin to lose trust in this idea of information. And that is very important, particularly in the legal profession. Bias and discrimination, we've talked about that. When you're doing hiring decisions that are made online, the algorithm may have built-in biases. So if you go to apply for a job now, there's all kind of job sites. You never talk to a person. It's not like you send in your resume and hope somebody looks at it. A computer looks at your resume, and it cross-references all kind of criteria, some of which may actually have inherent discrimination in them. We've already talked about, for example, in facial recognition, particularly with black faces, clearly artificial intelligence has not gotten to the level where we are uniform in our ability to recognize faces and discriminate in a positive way among and between people. So what'll happen? Sadly, of course, there'll be job losses. There'll be wage discrimination, because with artificial intelligence, we will be able, of course, to eliminate certain jobs. And you think about, well, what might be eliminated? Data entry, for example. You don't really need somebody. When I was in college, I worked on a huge IBM computer and I did data entry. You don't need me anymore. All of that can be automated. Customer service, grocery checkout, graphics, deference to our translators and interpreters back there can be done by artificial intelligence. Manufacturing assembly, that's already there. Financial analysis. But what can't you replace? You can't replace emotional intelligence. That is something that artificial intelligence has not yet done. That's a challenge that it wants to get to. You can't replace decision-making that uses human thought. And you can't really completely replace creativity, thank heavens. But some of the other concerns we have are, of course, data privacy invasions. With the ability to have this massive data, we're worried already about data privacy invasions. Europe really has been the lead in this area internationally with its data privacy regulations. Surveillance of employees. Already employees are concerned that their employers are monitoring them. Just add a little AI, and you won't be able to even move your finger without your employer knowing. There will be exacerbated inequality as a result. And I want to mention intellectual property infringement because that's very important. We talked about the large language model. We wouldn't have generative AI, which if you can imagine, and I'll give you just sort of a non-technical version, what generative AI is doing is it is combing the web and it is combing whatever data is out there, amalgamating it, and then turning out a product that is in human text. Well, the question is that legal? And we have two major lawsuits in the United States now, one on the East Coast brought by publishers, one on the West Coast brought by creative and Hollywood people saying no. Because when you're taking that scraping and looking at all that data, you're violating my copyright and my intellectual property. We don't have an answer to that yet, but that really is the next coming legal battle that we're seeing. And I read a lot on electronic books, and I saw on a book I read for the first time a week ago a warning that said, this book may not be used by generative AI as a database. Well, it was kind of a stupid book, and you can't even imagine it would be worth anything. But just as you see copyright notices, you'll begin to see these warnings like, don't use my data, hands off, basically. So I want to move now to a real life example, and that was the writers' strike in Hollywood. So last year, we had a 148-day screenwriters' strike. That's a long time. That's why right now you don't see as many movies coming out, because nobody was writing the script for those. It was frozen. And there were others in the creative industry that joined the writers' strike in effect. So in the end, what the writers were concerned about is, first you have to have like a little plot line in order to get going on a movie or book or whatever. They were concerned that AI would just generate that. And for many people, you don't get paid a lot, but if you do 10 or 20 of these, you can help you make a living. If AI did that for you, there is no creative job for you. This was really a battle royale, and ultimately, both the writers and the studios agreed that artificial intelligence is not a writer. So if you have a contract or a labor agreement about writers, AI is not a writer. So they ultimately gave the writers control over the use of AI in generating storylines. That was a major accomplishment. So it basically said to the studios, you can't use AI to replace us. So I think that we viewed this as the first of many of these battles over the use of AI in the creative world. General adaptation of that is in author inventorship, both copyright and patent. And so there's a lot of similarities to what happened in Hollywood to what's happening generally, internationally in AI. And generally, almost every country agrees that an inventor or a writer has to be a human. Okay, I'll take you to an kind of an old-fashioned example, and that was the monkey. So there's a great example in the copyright world where a photographer set up a camera in the jungle, and the monkey snapped the picture of himself. So it was a monkey selfie. And first the photographer said, that's my work. And the court said, no, the monkey did that. You didn't do anything. So then people sued on behalf of the monkey. Okay, let's give rights to the monkey. And in my court, the Ninth Circuit, we said, yeah, but the monkey is not a human, and the monkey can't have a copyright. Well, that's just a precursor example to where we look at AI. And there needs to be, in this intellectual property world, some modicum of contribution by a human. So the question is, can we reach some, I guess, compromise, accommodation, where we have not a replacement of AI, but we have some kind of partnership between AI and humans? And the question we always ask is, well, who benefits? Is it just a small number of people? Will there be fairness? Will there be access? Or is it yet one other opportunity for economic discrimination? We've already had reference to the various regimes. In the United States, we have no national AI Act. We have a presidential directive, and like many of these, it looks at safe, secure, trustworthy, protect equity and civil rights. That's very common in all of these. In Europe, of course, you actually have legislation. China also has a new cybersecurity law, looks a lot like these others, and a lot of individual countries have now adopted their laws, even in Europe, even though they have the AI Act, some of the European countries have adopted their own. We have the OECD principles and we have the G7. So we really have this panoply of acts, principles, and directives that are crisscrossing internationally. I think in the end that it will matter quite a bit, because if we can cooperate on some fundamental principles, it will help drive a responsible development of this technology. That's the concern. And also the concern is that you'll have certain countries or bad actors that are using AI in a way that basically is pernicious. So in conclusion, I can say that there will be enormous impact in the labor market, flowing down, of course, to the legal construct of how we think about AI, whether it's in labor or intellectual property or privacy, of course, a major area. And I think that all of us having this conference today, it was really a brilliant idea, because we're all struggling with the same concepts, and we're all trying to think about how do we think about it. So I've tried to just give you some construct and something to think about. I will end with a quotation by a science fiction writer, Isaac Asimov. And he says, basically, when you get into discovering the limits of the possible, any sufficiently advanced technology is indistinguishable from magic. And I thought that was a great quotation. So I asked in a conference I was in with Brad Smith, the president of Microsoft, and I said, do you think AI is magic? He said, no, it's just an algorithm. And I said, but Brad, we have to make sure that there's a human touch to that algorithm. Thank you.
Thank you, Margaret. It was a really interesting presentation. And now I would like to introduce Honorable Leonie Reynolds, the president of CCGA. She's coming from the back. And speaking about the apes, I read in an article that in Spain they are trying to introduce the law which will recognize the human rights to apes, because scientists found out that they have some kind of feelings. So this case about copyright in Spain could go differently. Please, Leonie.
Thank you, President Sessa. I think I'm already responsible for giving him perhaps a small heart attack this morning on the basis that I think he was going to have to make this presentation himself. I'm grateful to my UK colleague who informed me as I was sitting outside reading my paper that in fact the conference today had been moved into this room. So thank you, Tim, you've spared me some more blushes. I'll start the presentation by, I suppose, going back to where I was on Friday by advising how we come to creating, I suppose, or designing these opinions, clearly with the input of the 44 member states who are represented on the CCJE. I did furnish the opinion to I think it was Giacomo. I don't know if it has been circulated, but for anybody who's on Wi-Fi, you can go into the CCJE website and you will see that opinion from last year, the one that I'm going to make reference to now, which is the use of assistive technology by the judiciary. In the preparation of this opinion, we engaged, or should I say the Council of Europe engaged, Dr. John Sarabji, who is in fact a practicing barrister in the UK and who had assisted the judiciary there with, I suppose, upgrading their own system. And clearly he had a lot of expertise in this area. He is now, I think, no longer practicing, but is an associate professor with UCL. So as I say, we were very grateful for the expertise in the area. The questionnaire then was designed by him. 44 member states furnished their responses, and he then is responsible for collating those replies. Thereafter, the working group that I referenced on Friday, which approximately has 15 members engaged in that, put together a draft opinion. We meet twice during the year, and then in December it's brought to plenary where all 44 member states, as I've outlined, are represented, and we debate obviously issues that are of importance to those member states to ensure that the final opinion represents, I suppose, as much agreement as is possible when you have input from 44 member states. Sometimes, as you can imagine, the meetings get rather heated, but in any event, we always seem to manage to reach consensus at the end of the day. If you have the opinion before you, you will see that I'm going to go through it and make reference. Obviously, it's a lengthy opinion, so I won't go through it in fine detail. I also notice, in fact, that some of the speakers have already made reference to certain parts of it. So rather than giving you repetition, as I say, I'll go through it as quickly as I can. The introduction, as I say, sets out where our starting point is, and it refers, in this instance, obviously, to the Magna Carta that I made reference to on Friday, of the judges, which was prepared in 2010. That was bringing together principles from the 10 previous opinions that, the 9 previous opinions that had been drafted by the CCJE. Thereafter, it makes reference to opinion number 14, which was entitled On Justice and Information Technologies. Now, if one had an opportunity to even glance back at that, it's obvious how outdated it is, I suppose, and it highlights the advances in technology since then. However, we do make reference back to it because there are some principles which apply equally in each situation. Thereafter, we come to the purpose and the scope of the opinion, and that's at page 3. And effectively, we outline how our opinion is effectively there to examine the advantages and disadvantages of the use of assistive technology by the judiciary. It stresses the importance of developing and using technologies in ways that maintain and indeed, where possible, enhance the fundamental principles of the rule of law. It is used, or indeed intended to be used, to promote speed and efficiency in the administration of justice, and it should, of course, particularly enhance judicial independence and impartiality, of course, having regard to the European Courts of Human Rights, Article 6, to maintain the independence and impartiality of the judiciary. We go on then to state that the scope of the opinion is limited to the use of specific forms of modern technologies, including the use of artificial intelligence to support human adjudication. In other words, support it as opposed to replace it. And again, we're back to the guiding principles, Article 6 of the European Court of Human Rights. We then look to general uses of technology, and I suppose the starting point is any judiciary's ability to secure access to justice, the resource challenge that's going to be there. So the IT system is clearly only ever going to be as good as the resources that are made available to the judiciary, firstly to implement such a system and then thereafter to rely on it, maintain it, and to train, obviously, its judges in relation to the use of it. And it was interesting to note, just in discussion the other night with some of your German colleagues, that in fact the funding appears to in fact be different from one federal state to the next. So it seems that if you're working as a judge in Bavaria, you have the best IT available to you. If you're working in more, I suppose, well, less financially resourced federal states, you may in fact be in a courtroom that doesn't have access to Wi-Fi, which seems almost incredible in this day and age. So as I say, that clearly is one of the challenges. If the resources aren't made available, then your hands are tied from day one. We have then noted, of course, that states face emerging challenges to the delivery of justice, and we're referring there obviously to the pandemic, to state emergencies, and how we all had to rely on whatever technology was available to us to ensure that the justice system continued to operate as best it could. And again, that's having regard to the resources that were made available to the judiciary to enable them to continue their work and to do so in a safe and effective manner. You'll see then we come on to the specific uses of technology, and in that regard, reference has been made already to a lot of these. The first one we deal with is data tools. Firstly then, if you look at the administration and case management data tools that are available, clearly they can assist with the efficiency and smooth running of a judicial system. Basic data tools, of course, such as language or evidence translation. I'm sure certainly amongst our European colleagues we're all familiar with DeepL or some of those other programs that are available to us for translation services. Anybody that has used them perhaps might say, well, they're not perfect, but again, it's a matter of using them and then I suppose using your common sense to decipher what was intended in the translation. We go on then to discuss other benefits of data tools, where data extraction from case documents may be analysed by data tools to help promote access to justice by providing more accessible information to the public. So we're back to the issue of transparency. Clearly, it's important from the judiciary's point of view that there's transparency, and data tools can assist in, I suppose, where it's available to the public to see how the system is running, what type of backlogs there are, and I suppose how quickly cases are getting on for hearing, that type of information. So in addition to that, obviously then there is the, I suppose, analysis of case information, which can promote the effective triage of cases. We detail then to some extent other, I suppose, benefits such as settlement promotion, how data tools can assist in judicial decision making, always assisting, never replacing. They can help promote speedier and more cost-effective legal research and judgment, and indeed the preparation of orders, where duplication in work can be now dealt with, I suppose, by programs that will make it much more simpler to use and indeed more cost efficient. We then go on to look at smart research, again coming back to the same type of thing. E-filing and proceedings, I suppose we now realise, are basic prerequisites for the effective use of technology in judiciaries, and they undermine judicial support systems. Technology of this nature, of course, came into its own during the pandemic, where it was difficult to attend at offices for the lodgement of proceedings. So obviously the initiation of proceedings online is of great benefit. Service also of documents electronically. Again, during the pandemic, we saw the benefits of that, where such facilities were available. And indeed, where they weren't, I think certainly it brought about a speedier, I suppose, implementation of that type of data tool to assist the judiciary, having regard to the challenges posed by the pandemic. We then look at case tracking and case management system. Again, data tools can assist in the assignment of resources, the administration of caseloads, informed resource allocation, and again, as I say, and such information being made available to the public for the purposes of transparency of the judicial system. It can also assist in effective tabling and hearing scheduling, case distribution, compliance monitoring. And the next one we look at is the management of mass claims. And again, I hope German delegates don't mind me referencing again how it can assist in that regard. But certainly, from the point of view of a small judiciary, maybe like Ireland, such systems can greatly assist in identifying and grouping together the management of test cases. And in that regard, we were discussing the BMW cases, which I understand there were approximately 800,000 in Germany, spread across various federal states. And rather than grouping together the issues in what I understand were there were 4 issues that were common to most of these cases, and rather than adopting the approach of identifying these and putting forward 4 test cases, it appears that the judiciary had to deal with all 800,000 cases. Now, if one looks at that as an example, one can immediately see what a saving on resources financially, not just for the judiciary, not just for the central federal states who are actually funding these, but also for the litigants, that those who are litigating can actually identify from a test case whether or not their claim has any likelihood of succeeding or otherwise. So I think the management of mass claims is certainly one that would assist greatly with the efficient and costly, I suppose, or definitely financially astute way of dealing with such cases. Again, identification and assessment of issues and evidence, well, that will follow. Back to, again, to open justice and accountability, as I say, transparency for the public, to see how the judicial system is functioning, what type of delays are there, etc. We then look to hybrid hearings, and I think possibly those judiciaries that hadn't been using such facilities, whether by way of video conferencing or otherwise, were probably forced to do that during the pandemic. And I think possibly we've all identified now the advantages and disadvantages of such hearings. Obviously, where cases during the pandemic had an urgency to them, it was preferable to have some way of dealing with them rather than no way of dealing with them. But I think we have probably now all identified that hybrid hearings tend to be suitable for certain type of cases, but certainly not for others. Identifying the possibilities, of course, of witness coaching, that type of thing, relying on, I suppose, secure link. For we certainly, our system, which is now being updated because of the pandemic, we certainly had serious issues with connectivity. Parties might have moved on to the next issue in a case, and you realise that some of the parties who were party to the proceedings, in fact, might have dropped off the line a half an hour earlier. So from a resource point of view, it certainly wasn't assisting us in getting our job done either efficiently or in it certainly was creating a greater financial penalty for some parties because cases were taking a lot longer than they otherwise should have. We then come on to looking at the challenges arising from the use of technology. And this again, of course, brings us back to Article 6 of the European Court of Human Rights, which provides, of course, for, amongst other things, for an independent judiciary. It requires a judiciary to be independent of the executive and the legislative powers. And in detailing then the challenges that arise with a view to ensuring that judiciaries are in compliance with Article 6, we look at what we have identified as the substantive challenges. And the first one is the judicial independence challenge, as I've said, and indeed often the implementation of technology is the responsibility of the executive. So therein lies a problem at the very outset. Effective data security and protective measures require effective, independent oversight of technology used by the judiciary, and that is obviously essential. We turn then to AI, how it poses several challenges to judicial independence. It may undermine judicial independence, and this is particularly the case where design and implementation are outsourced by member states to private companies. We all know that there are a limited number of private companies who are carrying out that work, and it clearly then results in a design risk. It also, as previously referred to, can create problems of bias, as we know. That, I think, has been apparent from the use of the compass system in the United States, and I'm sure we'll probably hear more about that. But that was effectively a program designed to evaluate, I suppose, the issue with regard to recidivism of parties who were coming before the courts. And it did appear after an independent assessment of that system that, in fact, there was bias embedded in the system. Like any AI system, it's only the output is only as good as the input, and certainly I think the compass system that was being used was found wanting in that regard. Again, judicial decision-making is a highly skilled activity. So again, the idea that you can simply input data into an AI system and expect it to deliver the quality of decision-making that judges do simply, in my view, is just not sustainable. A significant training and experience is required by judges before they even sit to hear cases or indeed determine them, and it is only with that experience and training that they proceed up to, I suppose, higher courts, bringing with them such experience. We then look at the fair trial challenge, and that is that obviously, again, technology posing challenges to the judiciary's ability to secure the party's right to a fair trial as guaranteed by Article 6. And again, we look at perhaps chatbots producing false results, algorithms being relied upon that may or may not have the correct results. And again, judicial oversight clearly is what's required. Care, again, needs to be exercised where hybrid hearings are concerned. And again, we're back to this risk of coaching of individuals off camera and issues that I've already identified. A move away from physical to hybrid hearings, of course, may also undermine the constitutional status of the judicial process, particularly its symbolic nature. And in that regard, I suppose we now, and most of us I'm sure have come across it at some stage, come across the witness who decides to dial in from their car and indeed may have a screaming child in the back. So the idea that justice is being carried out, or indeed seen to be carried out by parties in such a setting really is not, I think, ideal for any of us for obvious reasons. We look at the design challenge, as I've already outlined, the fact that there are a limited number of companies who carry out this work and do not have the expertise or training of judges. And I suppose the implementation challenge, again, where funding is made available for a technology system that's going to assist judges, well, it's not enough to design the system. You then have to implement it, and to implement it safely, you have to ensure that all judges are properly trained in its use. There's no point in having an ideal system which should do the job correctly when judges aren't trained properly in how to use it. The funding challenge, I've already made reference to that. That can clearly not just vary from one jurisdiction to another, but clearly can vary within jurisdictions where judges of a court in one area find themselves at a distinct disadvantage than judges who are sitting, dealing with similar cases in a state where there is greater funding available, greater training opportunities, and effectively their life is made a lot easier by having the assistance of advanced technology. And then we look at, and it's something that seems to be becoming, judges seem to be becoming more vocal about, is the well-being challenge. And invariably, I think most of us realised during the pandemic that sitting in front of a screen or doing hybrid hearings are not just not ideal because they take away the courtroom scenario and you're, as I say, relying on technology for a secure line, etc. But there is this idea that sitting in front of a screen all day obviously is going to have effects on judges' health. So the long and short-term health benefits, or indeed the issues that can arise, really, I think, probably need more research. But certainly, I think most of us feel that if we've been sitting in front of a screen all day, that is a more draining exercise than sitting in a courtroom and having interaction with witnesses, where you get, firstly, a much better sense of the validity of their evidence or otherwise. You can assess them in a capacity that you simply cannot do in an online position. So, as I say, I think it's possibly something we're going to hear an awful lot more about, but that research obviously will need to take into account, I suppose, where we've come from with since the pandemic, and the idea that we now perhaps realise that hybrid hearings are suitable for certain types of cases, particularly those of a summary nature, case management application, that type of thing. But certainly, in my view, majority of cases, it is not suited for. Whatever about video conferencing to facilitate a witness who would otherwise perhaps have to travel, and there are financial implications, then one might be able to see the benefits of that, and maybe where their evidence isn't highly controversial. But as I say, since, as I say, the pandemic, we, I think, have all educated ourselves on what hybrid hearings are best suited for. We are coming then, you'll be glad to hear, towards the conclusions. Legal and ethical framework for the use of technology. As already referred to by the earlier speaker, obviously it is vitally important that there is a legal and ethical framework in place for the use of technology by the judiciary. And such a framework obviously will better enable the judiciary as one of the powers of states to uphold the rule of law, and as it increasingly adopts and adapts to technology. The framework that the CCJE has put in place, and indeed the principles that are to be applied, have already, I think, been highlighted by an earlier speaker. But just briefly to go through those, and you'll see they come at the conclusion, for anybody who's following online, the conclusion, page 17 of the opinion. And the first thing, obviously, that we say is that the use of technology must, above all, respect the nature of the judicial process. We then detail the principles that we say are to be applied in using technology. We obviously are of the view that the use of technology must assist judges, but clearly the opinion does not look at replacing human decision-making of judges for the reasons that have already outlined, Article 6 and indeed other articles of the European Courts of Human Rights. The principles then that we say should apply in the use of technology are as follows. One must look to ensure that the rule of law is not undermined, that judicial independence and impartiality is not undermined, that judicial autonomy is maintained, that there is judicial oversight, accessibility and quality. In other words, we must have improvement of the effective and practical access to justice for all members of society. Interoperability and continuous improvement. Well, as we all know, technology moves so swiftly that it's not enough to put in place a system. It needs to be properly maintained. Funding needs to be set aside for that. Piloting speaks for itself. Non-discriminatory design and operation, as I've already referred to. Transparency and intelligibility. Accountability. Integrity, security and data protection, openness and privacy, funding, and then training and operability. So those were the principles that we determined were to be applied, and for anybody that wasn't familiar with any of the terms that we were referring to in our opinion, we put in place a glossary at the back. I think at this stage, 12 months on, anybody that wasn't familiar with them then is certainly familiar with them now. But that, I suppose, in essence sums up just how quickly AI and indeed technology develops. So thank you all very much for your attention.
Thank you, Leonie, especially to putting up the issue of fair trial and the right of a natural judge, which could be endangered by the use of EU. Okay, now I'm announcing a break of 20 minutes, not a half an hour, because we are a little bit late of schedule, and we will then start at 10:30. Thank you.
Thank you for your wonderful presentation on the